Hello and welcome to this knowledge clip on the Gabcikovo Nagymaros case. This case was brought to the International Court of Justice, the ICJ, in 1993 by two parties, the applicant, Hungary, the respondent, Czechoslovakia, which was later succeeded by Slovakia. This case concerned the construction and the operation of a series of dams along the Danube River that bordered the two countries. What does this case then have to do with international treaty law, you might ask? Well, almost everything, because the construction and the operation of the dams were agreed upon by the two parties through the conclusion of a treaty commonly known as the 1977 Treaty. In this treaty, the two parties agreed to build a series of dams, including the Gabcikovo Dam in the territory of Czechoslovakia and the Nagymaros Dam in the territory of Hungary. The parties also committed to ensuring environmental protection in the construction of the dam and ensuring that the works will not affect the quality of the river. Then what led to the dispute? The treaty came into force in 1978, and then works also began in the same year. However, after a few years, due to the public pressure and the criticism from the public in Hungary, the Hungarian government decided to suspend the work in May 1989. And in October, 5 months after, in 1989, it decided to abandon the works at Nagymaros altogether. Meanwhile, Czechoslovakia still continued to find alternative solutions, and in 1991 decided to unilaterally divert the Danube River, a solution known as Variant C. Then in May 1992, the Hungarian government decided to transmit a notification of termination of the 1977 treaty to Czechoslovakia, and it said that the notification of termination will have effect just 6 days after, on the 25th of May 1992. As I said, in 1993, the two parties decided to bring the case to the International Court of Justice. And among the questions that were raised before the court was, first of all, was Hungary entitled to suspend and then later on abandon the works at Nagymaros? Two, was Czechoslovakia entitled to conduct unilateral activities in the Danube River? And three, what was the legal effect of Hungary's notification of termination that was transmitted in May 1992? It is question 3 that we will focus on in this knowledge clip, the legal effect of the notification of termination. To answer this question, the court first looked at the 1977 treaty itself, and it saw that the 1977 treaty did not contain any provision relating to termination, denunciation, or withdrawal. So what does that mean? If a treaty is silent, that means that if a treaty does not contain any provision on termination or withdrawal, does that mean that a party to the treaty, like Hungary, is entitled to terminate the treaty? Or does it mean that no parties have the right to terminate the treaty? The court answered this by looking at the intention of the parties and the nature of the treaty. And even though the court did not say it, this examination reflected the content of Article 56 of the Vienna Convention on the Law of Treaties. This article says that if a treaty is silent, then it cannot be terminated unless the parties intended it or the nature of the treaty allows for it. The court looked at both of these factors, and it found that there was no evidence to show that the parties of the 1977 treaty intended it to be terminated, nor was the nature of the 1977 treaty warrant a conclusion that it could be terminated. In such a case, the court then concluded that if a treaty is silent on the issue of termination, then it could only be terminated on the limited grounds enumerated in the Vienna Convention on the Law of Treaties. Now, it is worth noticing that the court found that the provisions on termination under the Vienna Convention reflect customary international law. So what were the grounds that Hungary invoked in order to terminate the 1977 treaty? There were 5 of them. as you can see on the slide. Now, if you have taken a look at the Vienna Convention on the Law of Treaties, you will see that argument 2, argument 3, and argument 4 find their basis on the Vienna Convention. In particular, argument 2 is based on Article 61, argument 3 is based on Article 62, and argument 4 is based on Article 60. So we will now take a look at each of these arguments in more detail, and we will only focus on arguments 2, 3, and 4. Turning to argument 2, as I said, it was based on Article 61 of the Vienna Convention. And this Article 61 of the Vienna Convention allows for the termination of a treaty in the case of permanent disappearance or destruction of an object that is essential for the execution of the treaty. So what was this essential object in the view of Hungary? Well, Hungary argued that this essential object was the economic joint investment that was consistent with environmental protection and that was to be conducted or carried out by the two parties jointly. So this object that Hungary argued was not a tangible object. It was not the disappearance of an island, or it was not the destruction of the forest. It was a legal regime. Even though the court did not comment on whether this object could actually be something intangible like a legal regime, the court eventually rejected Hungary's arguments for two reasons. The first reason, in the view of the court, is that if there are any changes, if there are issues relating to the economic or ecological issues, the treaty itself provides for adaptation. And second of all, the court found that if Hungary argued that it was impossible to perform the treaty, it was because Hungary had not fulfilled its obligations under the treaty. And Article 61, paragraph 2 of the Vienna Convention clearly states that a party cannot terminate a treaty based on one party's failure to fulfill the obligations under that particular treaty. So the court rejected argument 2 raised by Hungary. Turning to Article 3 then in this article, Hungary relied on Article 62 of the Vienna Convention. And this Article 62 allows for the termination of the treaty if there's a fundamental change in circumstances, but it subjects these requirements, this termination, to very strict requirements under subparagraph A and subparagraph B. Again, what were Hungary's arguments regarding this particular change in circumstances? Hungary argued that there were 4 events or series of events that together or cumulatively would constitute a fundamental change in circumstances. And they were, first of all, the change in the political atmosphere, so the fall of communism. Second, the diminishing viability of the project in terms of economic values. Third, that there was progress in environmental knowledge. And fourth, there were developments in international environmental law. What was the court's response? The court found that first, the change in the political atmosphere and in the economic viability of the project was not closely tied to the object and the purpose of treaty. Therefore, they did not form the essential basis on which the parties concluded the treaty, so subparagraph A was not satisfied, nor do they radically alter the extent to which the obligations under the treaty are still to be performed. So subparagraph B was also not satisfied. With regards to the arguments on environmental knowledge and developments in environmental law, the court held that these changes or this progress was not unforeseen, and these was, as you can see, is one of the requirements under Article 61 of the Vienna Convention. And therefore, again, here the court rejected Hungary's argument based on Article 61 of the Vienna Convention. Finally, Argument 4. Argument 4 finds basis in Article 60 of the Vienna Convention, particularly paragraph 1, which allows for the termination of a bilateral treaty or suspension, depending on the circumstance, if one of the parties had committed a material breach of the treaty. And Hungary argued in this case that Czechoslovakia had committed two material breaches. The first one was that Czechoslovakia refused to enter into negotiations with Hungary in order to adapt the project to meet new legal and scientific developments concerning the environment. And second, that Czechoslovakia had unilaterally put in place Variant C, which also constituted a breach of the 1977 treaty. What was the court's response? The court argued that there was no evidence or not sufficient evidence to show that Czechoslovakia had refused to enter into negotiations with Hungary, and that when Hungary transmitted its notification of termination in May 1992, Czechoslovakia had not violated international law or the treaty by putting in place the Variant C. So in the court's view, Czechoslovakia, at the time of the notification of termination in May 1992, had not committed any material breaches, and therefore, again, it rejected Hungary's arguments. The court also drew attention to the procedural issues concerning termination, and the court said that even if one state is allowed to terminate a treaty, there are procedural requirements that need to be met, and these procedural requirements are found in Articles 65 to 67. Among which, for example, Article 65 states that termination can only take effect 3 months after the notice of termination is received. Hungary wanted to terminate the 1977 treaty within 5 days. And this was, of course, not reasonable and did not meet the requirements of Article 65. And therefore, the court concluded that Hungary's termination was premature. So for all these reasons, the court rejected Hungary's arguments, and it found that the notification of termination that Hungary transmitted did not have any legal effect. And I think this case, the Gabcikovo Nagymaros case, is a very fine example of the strict conditions that are presented under the Vienna Convention on termination. Even if a treaty is silent on the issue of termination, it cannot be assumed that termination is allowed. Termination is only allowed under very strict conditions. And these again highlights the stability in international relations that international conventions strive to establish. Thank you very much for your attention.